I want to welcome everyone for coming, and this should be a wonderful, wonderful session on the Roberts Court. This will be the first of a series of events Alliance for Justice is sponsoring on the record of the Roberts Court. And the conversation is so critical today because whoever is elected president in 2016 will have the power to set the court's direction for generations to come. By 2018, 4 justices, Ginsburg, Breyer, Scalia, and Kennedy, will all be in their 80s. The chances are pretty good then that the next president will have one and perhaps several Supreme Court vacancies to fill. That's almost a demographic certainty if it's a 2-term president. As the election approaches, more and more people are waking up to what's at stake for the law and what's at stake for our country's future at the Supreme Court. And that is the subject of our panel today. You can join the conversation online using the hashtag #RobertsCourt. Today's event builds on the remarkable October 12th special issue of The Nation magazine called The Case Against John Roberts, A Decade of Justice Undone. Kyle Barry, our Justice Program Director, and our staff were honored to be part of that project and contributed to one of the dozen essays featured in the issue. Today, 6 articles from the magazine will come to life thanks to the presentations by 5 of the authors, plus 1 pinch hitter. Allow me to introduce them all at once, then we'll begin. First, Bill Yeomans will address the court's assertive attacks on the long-standing principles of civil rights. Bill is a fellow in law and government at American University's Washington College of Law and a former U.S. Acting Assistant Attorney General for Civil Rights. Dorothy Samuels, a senior fellow at the Brennan Center for Justice, will discuss 2 completely uncontroversial subjects, guns and reproductive rights. Dorothy was on the New York Times editorial board from 1984 to 2014 and was executive director of the New York Civil Liberties Union. And we miss Dorothy from the New York Times. We used to love to badger her on a pretty regular basis. Professor Paul Butler will tackle the Roberts Court's approach to criminal justice and the death penalty. Paul teaches at Georgetown University Law Center and is one of the country's top scholars on race and the law and the author of the award-winning Let's Get Free, a Hip-Hop Theory of Justice. Jason Walta is senior counsel in protecting the prerogatives of large corporations, our class actions, and forced arbitration. Our good friend, Professor Herman Schwartz of the Washington College of Law at American University, will take us through the sordid history of the conservative majority's war on the rights of everyday Americans to seek justice in our federal courts. And finally, we are deeply honored to be welcoming later on Rhode Island Senator Sheldon Whitehouse, who will discuss Citizens United, one of the most destructive decisions in the history of the Supreme Court. The effects of that case currently wreak havoc in our political system today and are damaging to our political institutions in ways that we are just beginning to understand. Senator Whitehouse is one of the great champions of our civil justice system, and we are inspired by his courage in standing up for progressive values. In his essay in The Nation, he wrote, quote, "It's time for the rest of us to make our voices heard and demand a change." Today's panel is evidence that Alliance for Justice has taken his words to heart. We're thrilled that one of the great voices for change in the United States Senate will be here with us to share his insights. And now, without further ado, Bill Yeomans, get us started.
All right, thank you very much, Nan. Can you hear? Yes, okay. I'm delighted to be here, and I want to thank the Alliance for Justice for putting this together, as well as for its work on the issue of the nation, to which we all contributed. You will hear a great deal today, I think, about the importance of the 2016 presidential election for various areas of law. And nowhere is that election more important than with regard to civil rights, and in particular matters of race. I think it's fair to say that the Roberts Court has done more to dismantle progress on civil rights than any court since the 19th century. And indeed, the disconnect between events in our society and the Roberts Court is on matters involving racial justice is stunning, as we're witnessing renewed civil rights activism in response to police shootings, racially motivated violence, concentrated, segregated poverty, income inequality, structural racism, and daily racism. The Roberts Court has been systematically dismantling the legislative and legal victories of the civil rights movement. It has undermined efforts to desegregate schools, weakened protections against employment discrimination, rejected affirmative action, and gutted the Voting Rights Act. Too often, the court seems to have taken the view that, well, slavery, yeah, we had that was bad. Jim Crow, that was bad too, but we passed a bunch of laws in the 1960s. Those laws have been enforced for long enough. Now it's time to forget about race and move on. Unfortunately, the rest of society is not quite there yet. So the court's first target, the Roberts Court's first target, was Brown against Board of Education, the iconic case in which the court ordered the dismantling of segregated school systems. And in 2007, in Parents Involved, the Roberts Court held that Seattle and Louisville could not take voluntary steps to desegregate their school systems, and held that they could not take race into account to do that. It threw out decades of equal protection law and cynically interpreted Brown to support a prohibition on assigning students because of race to achieve desegregation. So Louisville had long been under a court-ordered desegregation decree, and when it finally convinced the court that it should be released from the decree, it wanted to maintain some of its gains. So it wanted to continue to consider race in a limited way in assigning students. The court said no. And incredibly, what that meant was that conduct that was required by the Constitution one day was prohibited by the Constitution the next. It's nonsensical. Similarly, Seattle had taken various steps to avoid lawsuits regarding its segregated schools throughout the years, and wanted to take race into account, again, in a very limited way in assigning students, and the court said no. And what this all led Justice Stevens in dissent to say outright that he was quite confident that no member of the court that he joined in 1975 would have joined the decision in Parents Involved. It's a real demonstration of how far the Roberts Court had moved from prior jurisprudence. So Parents Involved was particularly significant, though, going forward because it marked the first pronouncement by Chief Justice Roberts and Justice Alito that they were going to be rigid adherents to the ideology of constitutional colorblindness. That's the notion that the Equal Protection Clause prohibits any consideration of race. Constitutional colorblindness has great rhetorical appeal. It sounds nice, but it has no basis in the 14th Amendment. In reality, the modern notion of a colorblind constitution comes out of the reactionary backlash against the civil rights movement. The colorblind Constitution says that all consideration of race is suspect, whether it's a sign outside a bathroom that says whites only, or an effort to create inclusive schools. The evil that is being attacked is being conscious of race. So the genius of this approach is that it invalidates benign as well as invidious consideration of race, thereby undermining the scope and effectiveness of remedies for racial discrimination. So we're going to see the colorblind Constitution and the constitutionalists at work this term when the court revisits affirmative action in the Fisher case. This is the return of Abigail Fisher to the Supreme Court. She was denied admission to the University of Texas, and she contends that it's because of her race, because of their affirmative action program that takes race into account in a very limited way. The university has shown pretty conclusively that she would not have been admitted because of her grades and test scores under any set of circumstances. But she is back, and she lost in the lower courts the first time around. The Supreme Court sent the case back for further consideration. The Fifth Circuit said, no, we got it right the first time. And the court has taken it again. And I think this can only be the action of the four colorblind members of the Supreme Court who, in a fit of pique, have decided that they're going to grant cert in the case. It only takes four. And at least put Justice Kennedy on the spot to see if they can force him to go farther in eliminating affirmative action. So we will revisit that. In the little time that's left, which is, I'm told, none, I just want to point out that the court also devastated the Voting Rights Act in the Shelby County decision, and that's covered in the magazine in a piece by Ted Shaw. What the court said, and in an act of just stunning judicial hubris, was that times have changed. The fact that the Supreme Court had reauthorized the act in 2006 by a nearly unanimous vote simply didn't matter. It simply didn't matter that Congress had compiled a 15,000-page record in support of the continuing need for the law. Instead, the court was going to impose its own view of how far we have come in voting rights and eliminate the pre-clearance requirement of the act. The response has not been surprising. States have engaged in a kind of orgy of vote suppression efforts. The very day that the opinion was announced, the state of Texas announced that its photo ID law would go into effect, and announced that the redistrictings that had been already found discriminatory would go into effect. And other states have followed suit, and the loss of preclearance under the Voting Rights Act has been devastating. So finally, let me just say that replacing one justice will make an enormous difference in the progress of civil rights in this country. Substituting a more liberal justice for one of the conservative justices will make the 5-4 majority that opposes almost every civil rights initiative a 5-4 majority that will support segregation efforts, that will support voting rights efforts, that will support efforts to stop employment discrimination. Conversely, putting another conservative on the court will lock the current jurisprudence in place and lead to a generation of stymieing of racial progress. Thank you.
Well, Dorothy. Well, first, thank you, Nan. Thank you, Alliance for Justice. Thank you all for coming. Oh, thank you guys for coming. I'm going to actually...
Yes, thank you.
You know, pressing the button that says talk, that's very challenging for me. Thank you all for being here. We have very little time, and I'm supposed to talk about two issues, which is the abortion rights case that's just been accepted by the Supreme Court, and also a little bit building off my piece in the Nation about the Heller decision, but trying to cast forward a little bit. My colleague here referred to the consequences of replacing one conservative justice with a liberal. I think that's a little ambitious because I don't think in reality, whoever controls the Senate next time, or assuming a Democrat wins, let's hope, is going to be able to appoint a real liberal or someone with a compelling record on a lot of
For the record, I think I said more liberal.
more liberal, but even getting a moderate on the court at this point would be such a difference for so many of the issues folks in this room care about. And actually, it may seem, a little far-fetched to put abortion and gun rights together, apart from they're both obviously very controversial in some parts of America, like throughout America for different reasons. But actually, what unites the questions as they're going to or have gone recently to the Supreme Court are, I'd say, are mendacity and public safety. Those are the sort of questions that permeate, those are the issues and themes, to me, that permeate both cases. In the case of the Heller decision, the 2008 benighted decision that really invented a new individual constitutional right to bear arms, writing this piece for the nation was just an incredible revelation for me, because I hadn't reread it for a long time, and it is one wacky decision, just as a piece of jurisprudence, that is hardly the example of principled originalism that Scalia billed it as. Basically, it's principled only if you think it's principled to read out the first clause of the First Amendment, which is the pesky part about the state militia, that it being related to a militia or having some military purpose, having the right to have guns. There is, I think, I've read a lot of pieces, you probably have too, that suggest that what the court did in Heller, in that the conclusion was to confine the right. They only went so far to say this is a right to bear arms, basically, at least in the home and hearth, where the right is most powerful or prevalent, giving no reason for that observation, but that it didn't do much because it left open the possibility of reasonable regulations that were then in place. And I think that's absolutely a vast underestimate of the harm of this decision. And the main harm, it is true that nearly all gun regulations that have been litigated in recent years have been upheld, mostly existing regulations. But number one, it so fired up the NRA, empowered them even further, gave them further momentum to the point where they could even stop, after the massacre in Connecticut, any kind of movement on serious gun limitations or restrictions that would save lives. Two is, to the extent they made a rule that raised questions, called into question regulations that required people to lock up their guns in their homes and have locks on them so they're not operable when kids are around. I wonder how many people have died unnecessarily because of that. I wonder how many kids have committed suicides or adults. It's not so clear cut exactly what the number is, but it has to be pretty high. Another aspect of what happened, I think, the follow-up to Heller, is it just gave momentum to the movement that was already ongoing to normalize the presence of guns in our society, of loaded guns. And so the fight for what's called open carry or concealed carry has moved way ahead. I think it's now 10 states that changed their laws in the aftermath of Heller with the momentum to take away government discretion or limit government discretion in deciding who will be allowed to carry concealed weapons. We now have a major challenge two major challenges on the issue of concealed carry that likely will land in a Supreme Court. We don't know who will be on the Supreme Court, if and when it does land, and it likely will, including a District of Columbia case that you guys probably know about that I believe is being argued on Friday in the D.C. Circuit. We're awaiting a decision from the Ninth Circuit Court of Appeals. But as I think of it, and just one further thought on the guns, what is happening now in our society, it seems to me, is a massive change in the atmosphere for all the rest of us who don't tote loaded guns in the street and don't want to. And it is an infringement on our rights to speech and our rights to gather safely places. And it's happened, I would argue, without the sort of serious debate that it warrants. And depending on what the court is like, when ultimately the concealed carry question gets there, will either have that sort of consideration or not. Turning to abortion very briefly, everyone knows by now this case from Texas that's been percolating now a couple of years and had one earlier incarnation. It's threatening to leave these Texas law is basically threatening to leave this massive state with fewer than 10 clinics that perform abortions. It's going to leave some women, many hundreds of miles away from the nearest facility. And when I talk about I've talked a little bit about this issue of truth in the gun case. Well, the issue that's now going to the Supreme Court is as much about the integrity of the justice system in this country as it is about abortion rights. The future of abortion rights will be decided, basically, everyone is predicting, by Justice Kennedy, the swing justice, and which Kennedy we're going to get. But the implications here are really profound for respect for truth in how American courts decide cases. It is amply apparent on the record that the claim that these laws going now to the Supreme Court were passed to protect women's health were in fact passed with a pretty, a provable objective of cutting down on a woman's fundamental constitutional right. That's impermissible under court precedents, and it's really frightening beyond abortion for the implications for a range of other constitutional protections. And, we have a question now whether this court is going to rise to the occasion. I'm betting they will. But in another court, and I think this is a really sharp example of the difference it makes who was on the court, this issue of truth in this abortion case and how much we could trust judges in America to actually be concerned about relying on untruthful evidence and even making an attempt. The Fifth Circuit Court of Appeals chastised the district judge who held trials to try and get at what is the truth of the evidence and what is the implication for the supposedly protected right. They chastised him for making that effort. So this is, in another court, in another time, the entire court would just throw out these regulations for the obvious reason they're based on fictions, on testimony on testimony prepared by a quack who was discredited going back to the Casey decision in written rulings by judges, including in the lead up to this case. So the implications are huge. I believe with luck we're going to win this time. But another court, this would be a united decision because these rulings are an attack on the court system as it should be in America. Thanks.
So I think you may have the problem wrong if you think about what the problem was with what the police did to to Michael Brown in Ferguson, and what was the problem with what the police did to Eric Garner in Staten Island, and what was the problem with what the police did to Sandra Bland in Texas, and what was the problem with what the police did to Freddie Gray in Baltimore. You may think that the problem is illegal police misconduct. The problem is actually legal conduct by the police. The Roberts Court have created a legal platform for Black lives not to matter to the police. There's a famous law review article by a Harvard professor named Michael Klarman, where he's looking at criminal justice cases from the Supreme Court in the 1920s and 30s, cases involving people like the Scottsboro men. And he says the court was acting like it was doing criminal justice, but it was really doing race work. It was doing civil rights work. It was trying to make things fairer for African Americans in the South especially. And the criminal procedure was just its form. So the same thing is true now. The court has embarked on an explicitly racial project, and it's using criminal law, criminal justice as its means. What it's trying to do is to control, especially African American men. And in doing so, it's given the police these superpowers. So the Ferguson report from the Justice Department is a great document. It's kind of like the 9/11 Commission report, lots of stories. So one of the stories is about a woman who called the Ferguson police because she was being beat up by her boyfriend. When the police got there, he was gone. The police looked around the apartment and said, well, does he live here? She said, yes. They said, his name isn't on the occupancy permit. You're under arrest. Another story, a guy was chilling out in his car after playing basketball. And the police, for no reason, thought he was a pedophile, so they asked if they could search his car. He said no. They said, what's your name? He said, Mike. When they looked at his ID, his name was Michael, and so they arrested him for giving false information to the police. That's all legal, and it's illegal in part because of this conservative project by the Roberts Court. So there's any number of a parade of horrible cases we could talk about. We can think about a case called Scott versus Armstrong, in which the Atlanta police were trying to stop a guy for speeding. He should have stopped, but he didn't. He took off. They took off after him. They, in order to stop him, used deadly force. They rammed his car down a ravine. The car exploded, and he was rendered a paraplegic. The question before the Roberts Court was that permissible use of force by the police? The only crime he was suspected of was speeding, and they could have prevented him from being a danger by simply stopping the chase. They had his license plate number. They could have identified him. Court said no problem. It's fine for the police to use that kind of deadly force. So some of it is about the specific procedure. Some of it is also about a mood that the court advertises about how we should feel about these things. So there was a man in New Orleans who was on death row, wrongly convicted for 14 years. His conviction was overturned because he was innocent, and a jury awarded him $18 million, in part because the New Orleans prosecutors had flagrantly violated the law. In one of the hearings, the New Orleans DA, Harry Connick Sr., said he didn't know the law because he didn't read those law books. So it was flagrant abuse by the prosecutors. The court overturned that $18 million verdict. It said no problem. So again, when we think about this mood, there's another case in which a man was convicted. He wanted to appeal his sentence. The judge said, you have until this date to file your appeal. It turns out that the judge was wrong. So he wasn't able to file his appeal. He took the case to the Supreme Court. He said to the justice, give me a break. You know, the judge himself gave me this date. The court said, it's too bad. You don't get to file your appeal. We don't care what the reason was. So again, it's this fundamental disrespect for accused people that the court is well aware has extraordinary harsh racial consequences. It's part of the reason why there are 2.5 million people in prison, why we lock up more people than any other nation in the world. It's not entirely a steady drumbeat towards the right. There have been a couple of cases, mainly involving technology, where the court is more sympathetic. Some people do the analysis, if the justices can see it happening to them, then they're more sympathetic. So with regard to cell phones, the court has granted more privacy from the police based on what's on your cell phone. And there's also finally some good news with the death penalty, mainly because of a prediction by Justice Scalia that soon the death penalty will be ruled by the court to be unconstitutional. I don't think he means this court, and I don't think he means in the next 5 years, but I think most folks think that's right. So 2 of the justices now, Justice Breyer and Justice Ginsburg, are on record as saying the death penalty is unconstitutional, period. We can't tinker with the machinery of death, to use an earlier justice's analysis. It's impossible to do that to make it fair. And so mostly bad news, but a couple of beacons of light.
Hi, I'm Jason Walta. I want to start by thanking Nan and AFJ and the other panelists for being here. It's been really illuminating to hear what you've had to say so far. I'm going to talk about workers' rights issues, labor and employment cases, but what I'm going to focus on almost exclusively is Friedrichs versus California Teachers Association. This is a case that's pending this term, and it deals with the constitutionality of what are called agency fees. And what are agency fees? I'm going to digress a little bit to explain what those are. First of all, in unionized workplaces in the United States, no one can be required to join a union and to pay dues that support the union's political and ideological activities. But when a workplace is unionized, the union has a legally enforceable duty to fairly represent everybody in the workplace, including union members and union non-members alike. And so what this creates in a unionized workplace is a kind of classic free rider problem, where you get all of the benefits of being represented by a union, but you don't necessarily have to pay for them. And so your economic incentive in that case is to not pay for them. About half the states have laws that correct this free rider problem. And those laws say that non-members who decline to become members can pay what's called an agency fee. And this is a discounted fee that's lower than the amount of union dues that covers just the union's collective bargaining and negotiation and grievance processing, the kind of humdrum stuff of collective bargaining, but doesn't subsidize the union's political work or the ideological causes it supports. So that's what an agency fee is. And nearly 40 years ago, the Supreme Court said in a case called Abood versus Detroit Board of Education, and they said it unanimously, that these kinds of arrangements are perfectly constitutional and consistent with the First Amendment, as long as the agency fee that's being required of non-members supports the collective bargaining activity of the union and doesn't require the non-member to subsidize politics or the union's ideological activities. The First Amendment is not offended. Fast forward nearly 40 years to today, and now comes Friedrichs versus CTA, arguing under the banner of the First Amendment that Abood was wrong, that it should be overruled, and that agency fees should be declared unconstitutional throughout the country in all public sector employment. And so, in effect, the ruling that they're asking for is a constitutionally enshrined national right to work law for the public sector. Well, how did we get here? Well, first, the court certainly helped things along the way. You have 2 Roberts Court decisions, both written by Samuel Alito, the first in Knox versus SEIU in 2012, and then in Harris versus Quinn in 2014, both saying in dicta, disparaging Abood, questioning its rationale, and this really kind of sent up the smoke signal to conservative movement lawyers and conservative ideological groups that this was their opportunity to have Abood revisited, and they have done that. Friedrichs was filed by a lawyer named Michael Carvin, who you might know as the lead lawyer in the most recent attack on the Affordable Care Act, King versus Burwell. He was part of the legal team for the original legal challenge that the court rejected in NFIB. He was also one of the lawyers for Bush in Bush versus Gore. So kind of the quintessential movement conservative lawyer. And if you look at the amicus briefs that have been filed on behalf of the plaintiffs, it really reads like a kind of roster of the Koch brothers groups. You've got the kind of big league teams like Cato and the National Right to Work Foundation, and then you've got all of the kind of farm team Koch brothers organizations like the Buckeye Institute and the Mackinac Center, which are kind of the regional Koch brothers outfits. And so the plaintiffs and their supporters have been quick to characterize Friedrichs as a case about worker freedom and workers' rights. But the bottom line is this: the Roberts Court has been extremely inhospitable to workers. It has adopted stingy interpretations of the anti-discrimination laws, of the Equal Pay Act, of the wage and hour laws. And so what you have here is what I'll call the odd prospect of the court saying to workers, you have one and only one right that we are going to enforce in any kind of expansive way, and that is the right to force your coworkers to shoulder the expense of the benefits that you receive as a unionized worker. And certainly a loss in Friedrichs would make things harder for unions, but more importantly, it makes life harder for workers, particularly those who are the most vulnerable. Just this past week, all of the amicus came in support of the unions in this case, and there's one brief in particular, if you're going to read a brief, I think is of interest here. It's a brief filed on support of over 50 civil rights organizations, and what it shows is that unionized workforces provide a path to the middle class, particularly for vulnerable workers, women, people of color, that unionized workforces are the best at eliminating the persistent gender gap in employment. It's almost non-existent in unionized workforces. That unionized workforces provide anti-discrimination protections for LGBT workers who aren't protected by state laws or federal laws, and that those workforces provide essential protections for families, like paid maternity leave that aren't provided for under federal or state law. So those are the stakes in this case, and they're significant, and so it's very much a case to watch.
I'm going to talk about three areas or three parts of an area, which the area of civil justice, when people try to go to court to get some kind of redress from big business, sometimes big government and the like. It's almost always a David and Goliath fight. And the lawyers in the New Deal and in the Warren Court try to even things just a bit. And so they provided that the procedures by which lawsuits would be brought for wrongdoing by business and other large entities, large and small, that the procedures would be made as simple as possible to let people into court. And so one of the fundamental aspects of this, obviously the rules of these cases. And for a long, long time, for 60 years, it had always been the case that if you wanted to file a case in a federal court, you simply had to state a very simple, plain statement of how you were wronged. That had always been assumed by everybody. Volumes and articles were written around this, but it was very simple. And what it recognized is that when an ordinary person goes into court to file a suit against a big company or the government and so on, that ordinary person doesn't know very much. It's known as the informational asymmetry. In a discrimination case, you're going to get the information from the defendant's files, the emails and the notes and all of the records to show that the excuse given for firing somebody was a sham, and that there was animus or something else involved. Also, simply the records of how many people were fired, how many people who were women, how many people who were black, disparities, all of this stuff. The person who files the lawsuit has no way of knowing this, and he's got to get it out, she's got to get it out of the files of the defendant. Well, this was a little too much for the conservatives, who since the 1970s have been trying to cut in every way they could, trying to cut back on access to the courts. It goes way back to Burger's, Chief Justice Burger's first coming to the court in a civil rights case. So suddenly, out of the blue, first in a big antitrust case against AT&T, and then in a case against Rumsfeld and Ashcroft, name of the case is Ashcroft against Iqbal, involving alien Muslims who were thrown into the Metropolitan Correctional Center in New York as soon as 9/11 happened, abused terribly, and these two cases came along in 2007 and 2009, and the court suddenly came down with the notion that the claim had to be plausible, which meant you had to show that you had a solid basis for it, say in a medical device claim or something like that. But the evidence was often just not available to the plaintiff. The plaintiff knew how he or she had been hurt, but couldn't come up with evidence of very much more than that. And it also was very subjective, so that it left it up to the lower court bench, which was then heavily populated with Reagan and Bush judges, and still is at the levels, although obviously not quite so much as before the Obama administration, to apply their notions of what's plausible. And since there were an awful lot of former business lawyers and other right-wing lawyers on the bench, an awful lot of cases were dismissed. The effect was, in Arthur Miller's words, who wrote this piece, seismic. And that was the first terrific blow. An awful lot of civil rights cases, negligent tort cases involving very serious injuries were all thrown out. So that was the beginning. One of the ways in which people can file lawsuits and get some redress, of course, is as a group, in a class. That also had been developed a long time ago, refined during the time of the Warren Court in the mid-'60s. Now, the reason people bring a class action lawsuit is because lawsuits are very, very expensive. And there are several situations in which, but for the business of joining together, so that the recovery will be for a huge class, a very large class of people, of which the lawyer takes a piece, unless you have that, lawyers won't touch this case. For example, one of the first of these big cases in 2009 involved $30.22. But the defendant in that case was a telephone company, AT&T Mobile, and this involved millions of people. And they were charged with fraud and charged with bilking people of the $30.22. And it was just two people who brought the suit. So the court threw it out, even though the lower courts had gone with it. That was one of the first. The other one, the bigger one, was the Walmart case. There you have an employment situation where you have, in that case, I think something like 4,500 women workers, and from all over the country. And they filed a suit against Walmart, and if they had tried to file it on any smaller individual basis, it obviously would have been David against Goliath. So they all came together claiming that there was a sexist atmosphere that Walmart encouraged, that although Walmart had a sign on the wall saying you're not allowed to discriminate, it was understood that the managers who had complete discretion were really operating in an old boy network, in a system in which men were favored. And in fact, the numbers showed that Walmart had far, far fewer female workers in managerial positions than any of its competitors did. And experts came in with statistical analyses and the like. Scalia, who's led the charge on this, he didn't care for statistics. He said there were so many differences among all these people and so on. And after all, he said, there's a policy of the company that you're not allowed to discriminate. Well, a long time ago, Frankfurter and some other justices said that justices have an obligation to use the knowledge that all people have. And it's well established that when you give complete discretion in situations like that, whether it's black, white, whether it's male, female, personnel officers will tend to favor their own. And all of the studies of race in America show that at times this is almost unconscious in various contexts. People are more comfortable with people who look like them. So the case was thrown out. The Walmart women were forced to rely on 5 different regional suits. That was 2009. The cases are still in the early stages of litigation. Now, the class action situation does not come up exclusively in an ordinary case of a lawsuit in a court. It has had its most pernicious impact in the arbitration area. And as you know, some weeks ago, the New York Times had a huge 3-article series by a woman named Jessica Silver-Greenberg and 2 of her colleagues, in which she laid out all the many areas, all the many instances in which arbitration is used. And I'll just take 1 or 2 minutes more, and that is that it is used in almost every consumer contract, employment contract, purchase of goods and services. And what it means is that you've got to go before a secret court, usually before an arbitrator who's friendly to the business. You don't have rights of appeal. You don't have rights of discovery. These arbitration clauses are almost invariably, in some industries, like banks and elsewhere, associated with class action waivers in fine print. The arbitration clause is also in fine print. Nobody reads them. Nobody's expected to read them. And as a result, they've lost their right to sue in a court, lost their right to a class action.
What a remarkable panel. Thank you all so much. You really did bring those cases to life, and we're very appreciative. I think we're giving Senator Whitehouse a second to eat. All right, well, welcome. You've already been given a very glorious welcome, so we are delighted you're here, and you're just in time. This is perfect. So thank you for coming.
Thank you, Nan. It's good to be with you, and I very much appreciate having the chance to speak in front of this distinguished panel and this distinguished audience. The point that I'd like to make has to do with Citizens United. I think we all can appreciate what damage that decision has done in our politics, what one Kentucky newspaper called the tsunami of slime that has resulted is sort of an anecdotal, experiential description, but studies have shown that the amount of negative advertising has skyrocketed. At various times, virtually all of the dark money advertising has been negative, and false and misleading advertising has skyrocketed. At various times, the majority of the ads up on the air doing this have been false and misleading. So, far from contributing to robust debate, it has basically provided political artillery to well-heeled interests, and they have wielded that political artillery to great effect. As many of you know, I fight very hard on climate change. I think it's the issue of our generation. I think that my father's generation was the greatest generation. Ours may be the most disgraceful generation, back to back, because of what we failed to do on all of this. And I ascribe a lot of our problem on climate change to Citizens United. Because before 2010, there was a constant, steady heartbeat of Republican activity on climate change. Hell, John McCain ran for president as the party's nominee with a strong climate change platform. Now it's a flat line. And I think, based on my observation, that relates to Citizens United. And I think based on what my Republican friends tell me, oh, God, I want to be with you. Hang in there. But right now, I mean, we got to figure out how we get around the Koch brothers and all that. Those are the private conversations that take place. So it's had a real effect on our American polity, and it has had a nefarious effect on our American polity, and it has not increased debate. It has increased bullying and suppressed real debate. So it's worth taking a quick look at the decision. As you look at the decision, there are mysteries about it. First of all, how do you come up with the factual finding that corporate money can't corrupt an election? That runs contrary to our American history. Why do you make a finding like that when you're in a case that doesn't have a robust record, the way previous cases did and the way, say, the legislative record of the Tillman Act did? How about the traditional rule that appellate courts don't engage in fact-finding? What the heck are they doing? Forget the fact that it's wrong. What are they doing making those findings of fact anyway? And how weird to change the question presented so late in the case. Each one of those things, I think, potentially lends itself to being described as an error or a misdeed. But the point that I would like to make to you is that the worst sin of Citizens United is the underlying sin of the strategy that connects all of those elements. The court started with the unchallenged First Amendment proposition that regulation by Congress of spending in elections is fine under the First Amendment as long as its function is to protect against either corruption or the appearance of corruption. So, if you're determined to unleash corporate spending in elections, if you have an ulterior motive to do that, what do you have to do? You have to work your way around that somehow. How do you work your way around that? You work your way around that with the factual finding that corporate spending in elections can't either corrupt them or cause the appearance of corruption. When you understand the factual finding against the predicament that the court had, you see that it fits it right down to the First Amendment language, the way a key is designed to fit a lock. And when you look at how they got there, it gets even more interesting. Because in order to make that finding and have any credibility at all, they had to make sure they had no factual record. Because every factual record about corporate corruption of elections shows a rich, sordid American saga of corporate corruption of elections. It's virtually undisputed that in the period between the Civil War and the First World War, corporate corruption of elections was kind of the dominant American political fact. Historian after historian relates that. So you can't have a factual record in the case if your intention is to make that finding in order to be able to turn the key and get around the First Amendment problem. So that, too, had to be solved. And how do you solve that? You solve that by changing the question presented late in the case, when it's too late to establish a factual record. And then, of course, you've changed the question presented. You've made a finding of fact that is completely imaginary, but exactly fits the First Amendment key that you have to turn. To do all that, you've gotten rid of any factual record. To do that, you've done the unusual step of changing the question presented, and the whole darn thing violates the rule that appellate courts aren't supposed to do fact-finding. So, as I've summarized this, what are the odds? What are the odds that these conservative justices just happened to change the question presented, which just happened to prevent there being a robust factual record, on the very question where they just happened to need to make a false factual finding about corruption, which just happened, this of all times, to be the time they broke the appellate rule against fact-finding, and all of which just happened to provide the exact findings of fact necessary to get around the First Amendment control on corporate political spending. If you put those steps together, you don't see judges like umpires calling balls and strikes. You see judges working like a locksmith, carefully manufacturing a key, each of whose parts is precisely assembled to fit the tumblers on that particular lock that opens the door to unlimited corporate election spending. And the result, of course, has been this amazing new weaponry that we see now for special interests that have basically brought Gatling guns into a field of muskets and silenced debate on a variety of issues, but most particularly climate change. Now, I raise this because I think it's important that we continue to push back really hard on Citizens United. It may not be as bad as Dred Scott. It's probably worse than Lochner. It's somewhere in that really disgraceful decision range. And if we allow it to pass, then I think the court will just continue to build on it. Wouldn't surprise me if they said that all corporate speech directed to government was protected by the First Amendment and couldn't be deemed fraud. So that as long as you're trying to fix Congress, you can lie through your teeth. It doesn't matter how false, it would unwind the tobacco prosecution under the petition for redress of grievances clause. So where this could go could be pretty far. But I do think that, as people have observed before, just because you're on the Supreme Court doesn't mean you don't read the papers. And there are people on the Supreme Court, I think particularly the Chief Justice, who would like to have their gravestone not say tool of corporate America, but instead say distinguished Chief Justice of the United States Supreme Court from X period to X period. And so there are some restraints, but those restraints won't hold if there isn't that kind of legal commentary pressure back. And I don't think anybody has yet really put together the case for not just the error of Citizens United, but the deliberateness of it, the craft of it, the method of it. And when you understand its deliberateness, its method, and its craft, it is impossible to square it with Chief Justice Roberts' promise that he was just going to be an umpire calling balls and strikes. So I leave you with those thoughts. I live with the world that Citizens United has created, and I would love to see it return to the era before then when the Gatling guns were not allowed on the field of combat, and we just had regular musketry among the parties. Thank you very much.
Thank you. We'll take some questions.
Sure.
Oh, good. Senator Whitehouse would be happy to take some questions at this point, and thank you for that. I guess I'll ask the first one, which is, what's the best strategy for dealing with Citizens United? What can we do?
There's a legislative thing that we can do, because the two great misconceptions of Citizens United were that this dark, anonymous, corporate, unlimited spending would be independent of candidates and would be transparent as to who was behind it. So because those are the premises of the decision, we don't have to overrule a Supreme Court decision to vindicate them. And the key one is, I think, disclosure. If we can get that going, because the American public is really clear on that, then at least you know who's behind it. I very strongly believe that this new polling that we're seeing, this emergence of a massive distrust, contempt, and frustration with government that's now worse than concerns about the economy, has a lot to do with what people see on the television. Americans aren't stupid. When they're sitting there and they see an ad come up, they know somebody paid a lot of money for it. And they don't really much like it barging in, particularly when it's negative and it's part of the tsunami of slime. So now they really don't like it. And it's mysterious. And then it tells who paid for it. And it's Americans for Puppies and Prosperity, or some totally bogus group that everybody knows doesn't exist in any real life. It's not Exxon, it's not the Democratic Party, it's not the Machinists Union, it's just this thing. And so now there's an American sitting there that something out there that is so phony that nobody even knows what it is has enough money to try to control my opinion by buying TV time and bombarding me with this very stinky, negative, false advertising, which has a tone to it. People recognize it right away. And I think that's creating very strong public antipathy towards this, and that creates a very strong opportunity for us to push this through legislatively. I hope in the coming year, during the election season, while the face of these ads is right in front of the American people. So that would be the big thing. The other is just to keep the pressure on the court. I mean, they do read the papers, and not let them get away with this. We can't just say, okay, we'll adapt. This is the new way it is. This is not the new way it is. This is an absolutely wrongful way to set up American democracy, and in my view, it was deliberate. And that, I think, is a card that is harsh to play, and maybe there should be some good cops along with the bad cops like me, but I think that it's important to call them out on it. Yeah.
Can you elaborate a little bit about how you see the threat with the elevation of corporate free speech rights for regulation of bad corporate behavior?
We have seen a very significant apparatus develop in the last 30 or 40 years to propagate phony corporate messages. And it's gotten very sophisticated. I go back to the American Tobacco Institute. At the time, Liggett and Myers and Philip Morris and those people thought they were being really clever and crafty like coming up with an American Tobacco Institute. Oh my gosh, that'll really fool folks. It's an institute. Looking at what the apparatus looks like now, that's almost, I mean, it's quaint. It's like airplanes that had wings of canvas. Now, you've got an array. There are probably 20 of them. The work of Professor Brule and Professor Dunlap call a lot of them out. They've named themselves after everybody you could imagine to be proud of. Thomas Jefferson Institute, Ben Franklin Institute, James Madison Institute, George C. Marshall Institute, for God's sake. And that is a very powerful apparatus that works to serve the corporate interest in suppressing science and public health concerns and so forth. That was dealt a real blow by the tobacco civil RICO case. That case established the proposition that if you are lying and committing a fraud in the context of that activity, you can be held to account. And it was the Department of Justice, actually under President Bush, that finished off that case, although I doubt they ever would have started it. But they did finish it off, and it was a victory, and Judge Kessler on the D.C. District Court wrote a 1,200, I want to say, page opinion, just nailing down the facts, so there's no way the D.C. Circuit could flip her. And the result was a really, really powerful limit on that. If that limit is lifted, because if it involves government regulation, if it involves legislation, then all bets are off, that government shouldn't be allowed to regulate the speech of people petitioning for redress. You can see the argument. Then that whole machine goes into high gear and can lie and essentially commit what would, against individuals, be a full-on fraudulent racketeering conspiracy. But because it's pointed at government, they'd get a pass. That would be the worst outcome. And the fact that they've built all this machinery to do that, it's there. It's waiting to do this stuff. And it's operative on climate. I see these guys coming in. We had somebody from the Manhattan Institute testifying in the EPW committee today. They've got hundreds and hundreds of thousands of dollars from ExxonMobil, from the Koch brothers, Manhattan Institute, my you-know-what. Yeah. Yeah, I think organized political parties are in danger of becoming obsolete in the wake of this. There's already been press reporting that the Koch brothers' private political operation is now more robust than the Republican National Committee. There's a report today that in addition to all of the groundwork stuff that they're doing, all of the money that they're raising, all the messaging that they're doing, they actually have an intelligence group that is designed to do basically opposition research on groups that they disagree with. It's pretty darned robust. And I know that Majority Leader McConnell is urging that we find ways to lift the caps on parties so that they can begin to hold their own. Because he's beginning to worry that his party loses out to these groups, and then where's the control? So I think it's a real risk. Yeah.
Senator, I want to follow up on Nan's question about what we could do. There is an election coming up, as you know only too well, in a year, and we've heard from some of the dissenting justices, both in their opinion and outside, that including Justice Ginsburg, that they could well vote to overturn this decision or decide differently in a future case.
Yeah.
What comment would you make to the people in this audience and elsewhere about the importance of this election with respect to the future of citizens?
Well, the election is critical because the next president will make the appointments to any appointments to the court that open up in the next 4 years and potentially the next 8 years. So particularly if it's 8 years, there are going to be appointments to the court, and probably in some number. So having the court tip back to what I would call regular political control rather than corporate political control is really a vital piece. We absolutely have to get, in my case, I would argue Hillary, elected president. I think that's really vital, because otherwise, you build in a firewall of corporate justices that would take decades to unravel. The other way that I look at this, though, is that beyond the politics, there is a big American public out there, and they get a vote. And the vote that they're taking right now is that they think this really sucks. And the latest, a poll about 6 months ago showed that the American public by a ratio of 9 to 1, and I think the numbers might have been like 63 to 7, that kind of but it was a 9 to 1 ratio, thought that an individual could not get a fair shake against a corporation in the United States Supreme Court. And if you singled out the conservative, self-identified conservative Republicans in that poll, it was still 4 to 1 that an individual can't get a fair shake against a corporation in this Supreme Court. So irrespective of how the presidential race turns out and where the next appointments go, there is a point where the continued no sale that keeps ringing up with the American public, the continued misuse of this decision, the increasing obviousness that both its transparency and its independence predicates were flat out false. At some point, to restore its own credibility, the court may very well have to correct itself. And I've come to the conclusion in the last year that there's a reasonable chance that it's worth pursuing, that if we keep the pressure on this, the Chief Justice or Justice Kennedy might well relent and try to clean up their act before they're consigned to the ash bin of Supreme Court political history. It's that bad, and it's big. You know, when it's now dwarfing the economy as an issue, that's really, really big. And a lot of it on the right is just kind of general Tea Party fury with the world, but it's not, the numbers are way too big to just be Tea Partiers. It's everybody. Yeah. Professor. It's an interesting question. I guess I'd answer it the same way I answered the last one. Beneath whatever political games or maneuvers get played, whatever appointments or other things get done, there is a big American public out there. And in a democracy, ultimately, they will have their way. And what I think is really important is that we identify ourselves as being, fighting hard in the right places so that when they come over and realize, oh my God, we're there, and we have a record that will support them saying, okay, we'll trust you guys now because we saw that you were fighting for us back then, even though we didn't believe it at the time. So I think that we need to be undeterred by success that is not immediate, and patient in our confidence, but impatient in our actions. Because particularly on climate change, nobody in my daughter's generation is going to be denying climate change. That fight is over. So on the one hand, yes, we're trying to solve this problem before it gets completely out of hand and we leave a really damaged planet to future generations. But at the other time, we're also trying to make sure that history knows that some people fought hard and did the right thing. And we've got to have confidence that by fighting hard and doing the right thing, when the tide turns, there will be a recognition of that, and it will empower us to do other things that are also right because we will have earned the support of the public. That's a sensible answer.
Herman, do you want to?
Senator, you said when somebody asked that what happens in the election is critical with respect to the court, And that's been the major refrain here. And yet, I have heard almost nothing from Secretary Clinton or the other two. It didn't come up in the debate this Saturday night. It doesn't seem to come up, and I'm not the only one who's noticed that whereas Republicans do a lot of talking about the importance of the Supreme Court, I've heard almost nothing from our side.
Yeah.
And
Can I make a political observation?
yeah,
On the Republican side, judges have become a really, really broad-based, popular base issue, starting with Brown versus Board of Education, going on to Roe versus Wade, going on to Miranda v. Arizona. I mean, one by one, these decisions animated part of the right-wing conservative base and became battle cries for them. So if you're a Republican and you want to send out a fundraising email and you go on and on about activist judges and the terrible things that the court's forcing down our throat, big response. On our side, you might get like 9 lawyers who respond. It's just a very different political dynamic on their side versus ours. Has nothing to do with the merits, it's just the history and the practicalities of it. But it is a big deal for a Republican to be talking about, constitutional court and all that stuff. And it just hasn't caught fire with us the same way. Yeah.
I think some of us had hoped that Citizens United would be the
It's getting there.
would be the battle cry that would
It's getting there.
animate the Democratic side of the.
It's getting there.
Is that happening at all? Do you see it?
Yeah, I think it is. I mean, look how long it took Brown versus Board of Education and Roe versus Wade to really turn into very powerful social movements on the conservative side. So it doesn't kind of happen overnight. People have to live with the experience for a while, and I think the more ads they see, the more they're going to hate it. This is a train that only goes one way for the court. It just gets worse and worse. So I think it's happening, but they've got, decision after decision after decision for decades that they have milked and squeezed and used for political base animation. And as a result, they have a much more robust political reaction to it than we do. And politicians respond to that signal. I can promise you, if in the Democratic primary, judicial appointments got the same kind of buzz back that they did in the Republicans, we'd be talking about it. These people are not talking about things that the public isn't interested in. That's where they try to go. Sir.
I think right now, you're kind of average. Liberals feel pretty good about the court right now. They did the right thing in the marriage case. They did the right thing for well. But if you have
Kept Obamacare going.
if you have a 2015-16 term that's a bloodbath for progressives, labor on rights and things like that.
Yeah, there's a good chance of that.
Just to clarify that while concern or awareness is building about the stakes on political money, that in general, say in the general election, the Supreme Court as an issue may be a loser for the Democrats?
I don't think it's a loser. I think it's an issue that is more important to the Republican base than to the Democratic base. And that's why the Republicans talk about it more. It revs up their people. It brings them out. It's the rallying cry. Everybody's, waves the flags. On our side, we'll talk about Citizens United. We'll talk about dark money. But we really want to talk about income inequality. We really want to talk about a minimum wage. We really want to talk about family leave. We really want to talk about having the middle class get a break again. Those things. And there just isn't the same audience out there on our side. And I think for a lot of the reasons that you've said.
Jim?
Nope. Yep. Yeah, I think we have to be a lot more robust. It depends a little bit on what our situation is. I mean, I've been here for Judge Sotomayor and Judge Kagan. Those both went our way, so there wasn't, we were more making sure we defended those appointments. If the Republicans get another appointment and they try to bring another corporatist judge on, then I think it gives us a big opportunity to try to call that out. And particularly, I think, unless things change a bit, Justice Roberts' "I'm just an umpire who calls balls and strikes" image is going to be infamous. They're building a record. And if you look at their record on what helps corporate America versus what doesn't, it's a rout in favor of corporate America. If you look at what affects Republican election prospects, whether it's gerrymandering or the Voting Rights Act or campaign finance, every decision goes in the direction of what helps Republicans. If you look at the sort of ideological decisions about gun rights and Hobby Lobby, abortion, and things like that, over and over again, you see these cases that move the court ideologically to the right, hence Jeffrey Toobin's comments and Linda Greenhouse's comments and Norm Ornstein's comments. So there's a point where the record starts to catch up with them, and I think that will make it a very challenging hearing to try to appoint somebody who wants to expand that record. All right, I've got to wrap up, and I think you guys probably want to move on to other events and speakers, but I've been privileged to be with you, and I just want to close by saying how much I appreciate what Alliance for Justice does, what each of you does individually to help advance the cause, advance the argument, keep the flags flying, and keep bringing our muskets to the field of battle. Thank you.
Thank you. Thank you so much, Senator Whitehouse, and a big admirer of your leadership in the Senate. I want to thank our wonderful panelists for coming and for sharing your views and thoughts about these critical areas of the law. And thank all of you for coming and having lunch with us. And what a treat to hear from these 5 amazing activists, teachers, lawyers.